Welcome to Torts and Truth, and this is your decoded advocate. Before you answer a single question from an insurance adjuster, there is something they will never tell you. What you say in the hours following your accident can be permanently recorded, permanently reviewed, and permanently used to deny or reduce your claim. Every year, thousands of accident victims hand insurance companies the exact words needed to pay them nothing, not because they lied, not because they fabricated injuries, but because they answered one phone call without understanding what that call actually was. This is not a cautionary tale. This is decoded intelligence. By the end of this video, you will know exactly what a recorded statement is, what it is designed to do, and precisely how to protect yourself when that adjuster calls. Understand this before anything else. An insurance adjuster is not a neutral party. They are an employee or contractor of the insurance company, and their performance is directly measured by how much money they save that company. Their job is not to help you recover. Their job is not to ensure you are treated fairly. Their job is to investigate your claim and identify every legitimate reason to minimize or deny it. That is not speculation. That is in their documented role when they call you sounding calm, professional, and empathetic. They are conducting an investigation. And if you give a recorded statement without understanding the process, you are walking into that investigation completely unprepared. A recorded statement is a formal, captured conversation between you and an insurance adjuster. You agree to be recorded. The adjuster asks a structured series of questions about the accident, your injuries, your medical history, and your daily life before and after the incident. That recording becomes a permanent document inside your claim file. It can be reviewed by claims supervisors, forwarded to defense attorneys, and presented as evidence if your case proceeds to litigation. Here is what adjusters will tell you. It is routine. It protects you. It speeds up the process. Here is what they will never tell you. Every answer you give will be cross-referenced against your medical records, your prior statements, your social media activity, and any inconsistency, no matter how small, becomes a tool to challenge your credibility and reduce what they owe you. There are 5 specific manipulation tactics deployed inside recorded statements that most claimants never see coming. Takum bin, the early injury question. Within the first few minutes of the call, an adjuster will ask how you are feeling, or whether you are injured. If you say, "I am okay," or "I am not sure yet," that answer is documented immediately. When you report neck pain or a back injury 2 days later, they will reference that recording and argue the injury did not come from the accident. The medical reality is that soft tissue injuries frequently take 24 to 72 hours to fully manifest. Saying "I feel fine" the morning after is honest, but it is legally devastating. Tactic 2. The speculative admission. Adjusters will ask whether you feel any personal responsibility for what happened. Human instinct is to say, "Maybe I could have braked sooner," or "I was possibly going slightly above the limit." Even a partial admission is a legal concession, and in states with comparative negligence laws, any percentage of fault assigned to you directly reduces your settlement by that same percentage. A 5% admission can cost you thousands. Tactic 3. The prior injury excavation. They will ask whether you have had any previous injuries to the same area of your body. The goal is to establish a pre-existing condition and argue that the accident did not cause your injury. It simply aggravated a problem that already existed. The legal distinction between causation and aggravation matters enormously, because aggravation claims are settled for significantly less money. Tactic 4. The speed anchor. In nearly every vehicle accident claim, the adjuster will ask how fast you were traveling. Most people give an approximate number that feels accurate in the moment. If that estimate is even marginally inconsistent with the accident reconstruction report, the dashcam data, or a witness statement, your credibility is compromised from that point forward. Tactic 5. The open narrative invitation. At the close of the statement, the adjuster says those familiar words. "Can you just walk me through exactly what happened in your own words?" This sounds like an opportunity to tell your story. And for most people, it feels reassuring to finally explain their experience. What it produces is an unguided, unedited narrative, filled with speculative details, emotional language, and statements that can later contradict your medical and police documentation. The more you say, the more they have to use against you. Now here is the critical legal information that changes the entire dynamic. If the other driver's insurance company contacts you, you are not legally required to give them a recorded statement. You are not their insured. You have no contractual obligation to cooperate with their investigation process. This is a fundamental legal right that adjusters will almost never volunteer to you. They will use pressure language. We just need to confirm a few details, or this process cannot move forward without your statement. That is false. What you say instead is simple and exact. I appreciate you reaching out. I will have my attorney coordinate any further communication with your office. If you do not yet have an attorney, you say, I am not prepared to give a recorded statement at this time. Please submit your questions to me in writing. That is the complete response. Now your own insurance company is a different situation. Most auto insurance policies contain a cooperation clause, which means you do have a contractual obligation to provide a statement to your own insurer. However, even in this situation, you have the right to have your attorney present during that statement, and you have the right to request the questions in writing before you respond. Cooperation does not mean unprepared, unguided conversation. The alternative to a recorded statement is controlled, documented communication. There are 3 specific steps that protect your position. Step 1. Document before you communicate. Before speaking with any adjuster, compile the police report. Your initial medical documentation, scene photographs, and witness contact information. Every statement you make should be anchored in documented fact, not memory alone. Step 2. Consult before you answer. A single consultation with a personal injury attorney before providing any statement is legally protective. Most personal injury attorneys offer free initial consultations, and the majority of accident cases are handled on contingency, meaning you pay nothing unless they recover money for you. An attorney can review the proposed questions, advise you on how to answer precisely and factually, and be present during any formal communication. Step 3. Prioritize written correspondence. Whenever possible, request that the insurance company submit their questions to you in writing. Written questions allow you to review your documentation, verify your facts, and respond with precision. Phone calls are designed to produce spontaneous, unfiltered answers. Written correspondence returns control to you. Here is the final decoded truth. An insurance claim is not a conversation. It is a legal process. From the moment the accident occurs, the insurance company begins building a case, and every interaction you have with their representatives is a data point in that case. Understanding this does not make you difficult or adversarial. It makes you informed. The difference between a claimant who receives a fair settlement and one who is denied or systematically lowballed is almost always the decisions made in the first 72 hours, and those decisions begin before you answer a single question. Know your rights before they ask. If you missed our last video on the 72-hour window after a motorcycle accident, the link is in the description below. Watch it after this one. This is your Decoded Advocate, and I will see you in the next one.